And one of our friends joining us is attorney Robert Nagle with the Nagle Law Group. Hi, Robert.
Hi, how you doing?
We are well. Thanks for joining us.
My pleasure.
We are going to talk about short sales. A lot of people, just to explain them, and if you don't understand what a short sale is, it's when you sell your home for less than what you owe on the mortgage. And there are apparently some big misconceptions that realtors, as well as the public,
has in general about short sales.
Yeah. One misconception, Robert, you wanted to talk about was that there's a lot of realtors out there that are saying what to their clients?
A number of realtors are telling homeowners in Arizona who are underwater that if they don't sell their homes by the end of this calendar year, that they're facing a significant tax consequence next year because the Mortgage Forgiveness Debt Relief Act is set to expire, and it's unclear whether Congress will act to extend that law.
So they're telling them that they're going to owe taxes if they don't short sale by the end of the year.
Correct, because they owe more than the house is worth, and so if they short sell next year, that the difference between what they sell the house for and what the loan was will end up being a tax consequence for them. However, in Arizona, the Mortgage Forgiveness Debt Relief Act does not apply to most Arizonans. And that's because the Mortgage Forgiveness Debt Relief Act states that any amounts forgiven by a lender with respect to your primary residence, where the money was used to purchase or improve the home, you don't pay taxes on. Now, for most Arizonans, the first mortgage is what's called a non-recourse loan. That is, if the lender forecloses, they can only look to the home and no other assets that you have. And the IRS has provided that non-recourse debt is not taxable.
Okay.
So any forgiveness on your first mortgage isn't taxable. Then you have a home equity line. Most of us, unfortunately, have not used our home equity lines to improve our homes. We use it to pay off credit card debt.
Float on Lake Pleasant.
Buy a car. Big
buy
TV.
A car, things of that
big
nature.
Old TV.
So the Mortgage Forgiveness Debt Relief Act doesn't apply to use of the money in that way. You have to have used it on the home. So the only people who benefit from the Mortgage Forgiveness Debt Relief Act are those who have taken out a home equity line and they used all of that money on their home. And that's not that many of us.
So it is correct for realtors to say, do short sale your home before the end of the year if it wasn't purchase money?
If the loan that's going to get forgiven, which is typically a second mortgage, a home equity line, if you have a home equity line and you use the home equity line on your home, then yes, you should try and resolve that debt in the year 2012. If you did not use your home equity line on the house, or if you just have a loan, a purchase money loan in your home, there's no urgency whatsoever.
It seems silly to even ask you this after what you've just explained, which a lot of it went over my head, but why is it important to have a lawyer in a short sale? Obviously, I mean, there's a lot of moving parts. There's a lot going on from what you just said.
There is a lot going on. It's important to have a lawyer involved in a real estate transaction for many reasons. One, it's important to really understand the documents that you're signing. Many realtors try to assure their clients, whether it's a buyer or a seller, that the documents that they're being asked to sign are just form documents. Everyone signs them, so there shouldn't be any concern. But unfortunately, the documents are not drafted by neutral parties. Mm-hmm. The listing agreement is drafted by realtors on behalf of realtors. The purchase agreement is also drafted by the realtors and has a number of protections both for the realtor as well as the title company. And when you're giving these protections to parties who are not even involved who are not parties to the actual transaction, are not the buyer and the seller, it's the buyer and the seller who are suffering because they're giving up rights as to these other parties that are working with them. An easy example of that in the listing agreement. The listing agreement sellers are asked to sign, whether it's a short sale or a regular sale.
And the listing agreement, for those people that don't know, that's what you sign with your realtor when you want to list your home to sell.
Exactly. That listing agreement states that when your listing agent has brought in a buyer who is ready, willing, and able to close, then the commission is earned. However, most of us assume that the commission is not earned until the transaction actually closes.
Right.
Having a lawyer look at the form and correcting that gives the seller a little bit more peace of mind to know that they're protected in that regard. And in a short sale transaction, it's particularly important because you as the seller, being underwater, don't pay any costs associated with the transaction. So clarifying that it's not you, but actually the lender who pays the commission is also very important.
And that should be on the short sale addendum then, clarifying that on the extra, that verbiage?
Well, the short sale addendum itself addresses unique issues to a short sale that are not part of a traditional transaction where your house is worth more.
Well, we'll discuss the traditional one, but just for short sale, we should put, seller is to be the lender, seller is not to be the owner, that kind of clarification.
Those types of things. All costs and expenses to come out of the gross proceeds and not from the owner, things of that nature.
And then on a traditional sale, how do we clear up the problem of the commission? Do we put that on an addendum or just clarifying that the commission will be paid at close of escrow, when?
That's the easiest thing to do is just clarify either on some of the blank lines that are in the purchase agreement or in the listing agreement, or you can just do a separate addendum. I actually have more comments than the one I just gave you, but that's one that everyone, I think, can appreciate, because everyone assumes, not everyone, most sellers assume that they don't have to pay a commission until the transaction closes. And the reason I think a lawyer is important is because that isn't what the document says.
Right.
And then if you're the buyer, another common misconception is that the earnest money deposit that you put down, if you were to default, then all you would risk losing is the earnest money deposit. And by default, I mean you're supposed to close, all the conditions have been met, you're supposed to show up at the closing table with the money, but you say, you know what, I don't want to buy the house anymore. Most buyers assume they would lose their $1,000, $2,000, and that's the worst case scenario. But the purchase agreement does not say that. The purchase agreement gives the seller three options. 1, keep the earnest money as you would expect. 2, they can bring an action for specific performance and force you to close on the house. Very, very dangerous if you're a cash buyer, which means you have the wherewithal to do that. And 3rd, the seller can sue you for their actual damages. So if the next buyer who comes along pays $50,000 less than you were paying, then the seller can sue you for that $50,000 difference.
Wow. Attorney Robert Nagle with the Nagle Law Group. We'd love to have you back. Where can people contact you? We're going to have your information at thatrealestateshow.co. But if you'd like to give your website and your phone number.
Oh, sure. Our phone number is 602-595-3156. You can look us up at naglelawgroup.com, or you can email me at robert.nagle, that's Nagle, the bagel is giving me a lot of trouble, at naglelaw.com.
And of course, we'll have that information at thatrealestateshow.co. If you've got a question, go to thatrealestateshow.co and click the light bulb right under Ask a Question.